Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And we just got some breaking news on the SEC v Ripple lawsuit. Breaking: Ripple and the individual defendants have filed a letter with the court informing Judge Netburn that the William Hinman deposition has been renoticed for July 19th. Long story short, the initial date for this deposition of William Hinman was June 30th, if I'm not mistaken, but since the SEC had a motion to quash, basically they didn't want this to pull through, they didn't have a date anymore, and now Ripple came in to say, no, we want that date to be July 19th, and so now the judge has to put up an answer in the next couple of weeks, but we have kind of a decision sort of schedule now. They're saying to Judge Netburn that they would like a decision denying the SEC's motion to quash before then so they could take Mr. Hinman's that day. Take Mr. Hinman's deposition that day. And that's a really short letter. We write on behalf of defendants Ripple Labs Inc., Bradley Garlinghouse, and Christian Larson to inform the court that Mr. Hinman's deposition has been renoticed for July 19th to accommodate his availability. That was most likely the only spot where he could, or at least he said so, because, well, then the SEC could have filed no, I guess they now can do it because the SEC has filed their reply, right? And so now they could actually put up a new date because now all it takes is the judge to give her answer as to whether or not they can question him or not. And the rest of this video has actually already been recorded. I actually recorded it and just published it, or no, sorry guys, just uploaded it. But then I saw this news and was like, you know what, let me just quickly add this to the front of that video. So the rest of this video is going to be talking about what exactly is going on in this deposition, why I think there's like 99% chance that he will be deposed, and some other regulatory stuff that's going on right now. So enjoy, and make sure you press that like button right now if you enjoy these swift, crazy, quick updates, and make sure you subscribe too if you are an XRP holder. And by the way guys, do you think Ripple will win this lawsuit? Yes or no? Let me know in the comment section down below. Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today I want to give you guys a good update on the Ripple v SEC lawsuit. A couple of key pieces came out yesterday, and I think right now is a pretty good time to discuss those to the core. So, two important things came out. One was the letter from Elizabeth Warren to Gary Gensler, and two was the SEC's reply to the motion to quash response, basically. All right, so basically those two things came out. Right now, a lot of people in the comment section have been asking me, what exactly do they mean and what are the consequences? Because that's something we didn't really discuss too much about yesterday. Let's first dive a little bit deeper into the Ripple SEC case. There have been quite a lot of dates that have been put up, and what it kind of comes down to, the majority of those dates is basically Ripple is supposed to get a lot of info from the SEC because the court ordered that. And the problem is we cannot know if Ripple actually got them until very much later in either summary judgment or if Ripple actually did not get them and proposes to the judge for another basically request to get those documents or a court order to get those documents by a specific date. And if you're wondering what those documents are, a good part of that is basically emails that the SEC has delivered within and outside, depending on the exact emails and the exact communications, because some are quote unquote privileged, which basically means that some communications that the SEC makes should always be protected by law because it's a government agency, which is logical, and hence some documents will not be given over, but the majority of documents internally and externally that the SEC discussed XRP, Bitcoin, or Ether in have to be handed over to Ripple, and also some privilege log surrounding that. Basically just a lot of documents regarding that. Now, what Ripple has also been doing is meeting up with the SEC like twice or a week or something like that to meet and confer about different other documents. That's where they, for example, asked the SEC to investigate. We should say it a little bit differently. Ripple basically wanted to investigate Jay Clayton and One River Digital Asset Management, or whatever the company is called. And they now also have requested to basically put William Hinman on a pedestal, to basically, is it a pedestal or a chair, whatever, to question him, to depose him. The SEC, of course, did not want that. That's why they recently put up a motion to quash the deposition. And once more, the Ripple basically wants that because they claim that William Hinman has information that is quite unique to the case. And also, since he gave a speech in 2018, well, they want to talk about all of that. And actually, I believe down below here, we can actually find those 2 parts as well. Maybe not. Maybe we'll actually only find them in the SEC original. I'm not exactly sure. Okay, no, I think actually, okay, unfortunately, it's not in this one. Basically, when the SEC put up their motion to quash the deposition, they also had in the exhibits the speech from 2018, the letter from Ripple basically telling him to come up and be deposed and whatnot. Right now in this letter, it isn't, but this was Ripple's opposition to that motion. So, once more, the SEC didn't want him to be deposed because they put up a couple of points. Ripple replied to that, and now the SEC has replied to it again. Let's quickly go through a couple of these pieces, though, because it's actually quite important to understand. So, the SEC made a couple of points, and Ripple basically says the high-ranking official, once more, which the SEC claims William Hinman is, doctrine does not bar Mr. Hinman's deposition, because, first of all, he never was and certainly is not now a high-ranking official, where, again, the debate right now is about whether or not William Hinman, as the financial director, something like that, actually had a high enough position as the director of the Division of Corporate Finance to be qualified as a high-ranking official and where the doctrine would apply. Then the second question is basically if that ever applied. That certainly does not apply right now because he's not working there anymore. It's important to know the points that Ripple's been making. Then Mr. Hinman has unique first-hand knowledge relevant to claims and defenses in the case. Those two are the most important points. I don't know if there's actually any others. The SEC has no valid privilege objection to Mr. Hinman's deposition. That's it. They put 3 things up. So, the SEC has now responded to Ripple's letter, right? And once more, Ripple, these points they bring up because the SEC brought them, and they, of course, want to reply. And in a reply, you can actually not bring up new points, but you have to go into the things that Ripple said and basically give a more detailed explanation as to why you don't think so. Now, the first thing they say is that Director Hinman was clearly a high-ranking SEC official. I've read through this entire reply here, and what I can conclude right now is that I believe the SEC doesn't really know what they're doing, and they're just trying it out on the basis of different cases in the past. The difficult part here is where it basically they basically don't come back to the fact that even though he might have been a high-ranking official back then, which again, they cannot compare in the real world, they can only compare it to different corporations within the United States where a high-ranking official status was granted, they do not really come back to the fact that even though he is was it back then, he's not it right now. And here they say, the SEC has set forth authority that the director at the SEC is considered a high-ranking official whose deposition should not be permitted. And defendants do not address it other than to dismiss it as an out-of-district unpublished decision, which is because, well, Ripple says you never made it public that he's such a high-ranking guy, and if he were to be, for example, then it's more logical that his opinion and whatever he knew or said back in the past is relevant to the case, which brings us to point number 2. Director Hinman has no unique knowledge of any discoverable facts. These two things, however, are direct opposites of each other. If he was a high-ranking official, he most certainly has first-hand unique knowledge. 99.9% sure. If he was not a high-ranking official, well, then he can get deposed regardless, so whether or not he actually has this first-hand knowledge is not so much up for debate anymore because he's just a normal person, and if Ripple really wants to depose him because they think so, it's not that high of a burden. Because I believe the judge, too, can see, well, this individual was working there before and they want to question him. He's not any privileged person, so hey, it's possible. And also, I don't even think you guys have to read this one. I did read it before as well in the live stream and right now again. I also read Ripple's opposition prior. So this is, again, what Ripple put up first, and then the SEC replied. And I think Ripple also has the win on this one, where basically it's really hard for me to understand how the SEC can say with just a clear mind that William Hinman has no first-hand unique knowledge. It's so strange, in my opinion, to kind of think that. He gave his speech where basically the SEC's opinion was expressed. I don't really understand what the SEC thinks that Ripple should do right now. They're basically, once more saying it's privileged, but the conclusion of all of this is I think that Director Hinman will be deposed and that they will, the SEC will basically try to deny some specific questions that Ripple is supposed to ask. I would have also said that they should have addressed the last point, which is basically this one. The SEC has no valid privilege objection to Mr. Hinman's deposition. Well, because in the end of things, that's what it's all about. If the SEC could actually, show privilege where everything that the William Hinman has said is privileged, or everything that he has done or should have done, or whatever, all that stuff is just privileged and can never come into court like that or can never be questioned, they would have something. But right now, since they do not even show it, they would have to go on a question-by-question basis to deny or accept, mostly just deny, though, or try to deny. And well, we'll see that. But the deposition, I think, is going to pull through. I'm pretty sure on that one. Not a lawyer, but we have read so many different files right now. We've also read different cases and all this case study by now. I think we're on a clear path here. I think it looks good. And then, by the way, this Elizabeth Warren letter, I saw a lot of you guys stating in the comments section that it's actually a really good thing, and some of you guys said it's a really bad thing. Now, the reason it's good is because Elizabeth Warren puts a little bit of an end date on things, and since she is a Bitcoin hater to a certain degree, but, pretty progressive towards the entire crypto regulation forefront, it might be good. People said it's bad for two reasons. One, she will not get anything done, so she'll just be a laughing stock, so it doesn't really do anything. And partially because some of you guys even said in the comment section, I'm lying or I'm wrong. No, I'm not. She basically asked two things. What is the difference between a crypto exchange and a securities exchange? And what is the difference between a crypto and a security? So these two questions, if they're answered, if the SEC would actually say, well, they're the same thing, no, they should not have different treatment, it is basically from the perspective that every crypto is a security from the ground up until proven otherwise. That's actually what could be concluded here, and that's again one of the first things which the SEC could put up, which could have some dire consequences if really put through. Then one of the things I also saw in the comment section was that Warren and Gensler have a bond with each other where Gensler most likely read through all these questions and pre-approved them because it's a game. That's a theory I cannot confirm nor deny, but it's something to think about, that he saw these and was like, okay. Then another question people put up is, why this specific and abstract date of the 28th of July? I have no idea about what the reason for that is, but conclusion, it could be good because we could get some clarity and we could get some answers that were not expected. It could be extremely bad because if they say that crypto exchanges should have the exact same rules as securities exchanges, it basically considers them the same thing, would be strange. If they consider these assets traded on crypto exchanges to be the same thing as securities traded on security exchanges, that's also bad, but we can always get a good verdict, we can always get a good thing. In the end, you don't really know how they're going to twist it. These are bureaucrats, these guys most likely have a bigger plan. However, Gary Gensler is a very understanding individual, as we've seen it now. It might be that in the end of things, he'll come up with a good verdict or with nothing at all, and they'll just ignore this letter altogether, which basically would have bring us no further than we were a couple of hours ago. If you're asking me, by the way, where crypto is about to go right now, please understand that I never put up these predictions of where exactly we're going to go when. I have no idea whether Bitcoin will finally break this range today or in 3 months. I just know that worrying about it between now and then is an exercise in futility. My conclusion is, man, don't worry about those things. If you're a long-term crypto holder, why does it really matter, right? The S&P fell yesterday. The entire crypto market fell yesterday. Things fall together. And things don't necessarily gain together, but they fall together. When people fear in one area of the market, mostly they fear in other areas too, specifically if that specific market is higher. Right now, we saw a little bit of a bounce back upwards, though. Let's see how this is going to continue on forward, guys. I'm just excited about all of this, and I'm not too worried. Maybe that's something wrong inherently in me. I don't think so, though. I think this SEC case has also proven to us once more, there's so much stuff to be uncovered. There's so much stuff to be seen. It's a journey. We're just at like step 3 of 100, for example. We're just a couple steps in. There's right now no freaking foundation for cryptos in terms of regulatory clarity. It all has to still be built. And since we're so early in all this crypto, don't forget that we are still extremely early. There's not even freaking rules for how crypto should be treated. Yeah, if I kind of remind myself of that, if we have to take another couple of months before we'll see all-time highs again, who cares about that, man? It's about the longer-term journey. And as we know, this technology that we're into, it's going to be life-changing. I have some other articles and pieces about that. Let's quickly see, though, here once more. James also said it might be an orchestrated power play and to get more power from the SEC over the CFTC in the United States. Could be, there could be so many things going on. And this one right here, guys, we'll talk about it a little bit later because XRP has been put on a pedestal here a little bit. The International Monetary Fund, IMF, and the World Bank support the cross-border benefits of central bank-issued digital currencies. Oh my days, XRP Ledger, looking pretty good, looking pretty juicy. We'll talk about that a little bit later today. And then here we had, can Ripple bounce off the 50 weekly SMA and reverse the bearish trend? It could, but that's not really my niche. All right, so yeah. Guys, thank you all for watching this video. Hopefully you all enjoyed it. If you did, make sure you press the like button and subscribe. And I will definitely see you guys again in another crypto video later today.